Justice Alito delivered the opinion of the court. The Board of Education of Montgomery County, Maryland, also known as the Board, has introduced a variety of LGBTQ+ inclusive storybooks into the elementary school curriculum. These books and associated educational instructions provided to teachers are designed to disrupt children's thinking about sexuality and gender. The board has told parents that it will not give them notice when the books are going to be used, and that their children's attendance during these periods is mandatory. A group of parents from diverse religious backgrounds sued to enjoin those policies. They assert that the new curriculum, combined with the board's decision to deny opt-outs, impermissibly burdens their religious exercise. Today, we hold that the parents have shown that they are entitled to a preliminary injunction. A government burdens the religious exercise of parents when it requires them to submit their children to instruction that poses, quote, a very real threat of undermining, unquote, the religious beliefs and practices that the parents wish to instill. And a government cannot condition the benefit of free public education on parents' acceptance of such instruction. Based on these principles, we conclude that the parents are likely to succeed in their challenge to the board's policies. Section 1, Part A, Subsection 1. With just over 1 million residents, Montgomery County is Maryland's most populous county. According to a recent survey, it is also the most religiously diverse county in the nation. In addition to hosting a diverse mix of Christian denominations, the county ranks in the top 5 in the nation in per capita population of Jews, Muslims, Hindus, and Buddhists. The county's religious diversity is accompanied by strong cultural diversity as well. The county is home to several notable ethnic communities. For example, the Ethiopian community in Silver Spring is one of the largest in the country. And according to one survey, only 56.8% of county residents speak English at home. Most Montgomery County residents with school-aged children, by choice or necessity, send them to public school. As a general matter, Maryland law requires that resident children ages 5 to 18 attend a public school regularly during the entire school year. As an exception to this general rule, the state permits parents to send their children to private school or to educate them at home if certain requirements can be met. Parents who cause their children to be absent unlawfully from school can face fines, mandatory community service, and even imprisonment. Public education in Montgomery County is provided by Montgomery County Public Schools, also known as MCPS, one of the largest school districts in the nation. In the 2022 to 2023 school year, MCPS enrolled 160,554 students in its 210 schools and had an operating budget of nearly $3 billion. The district is overseen and managed by the Montgomery County Board of Education, a policy-making body consisting of 7 elected county residents and 1 student. In recognition of the county's religious diversity, the board's guidelines for respecting religious diversity profess a commitment to making, quote, reasonable accommodations, unquote, for the religious beliefs and practices of MCPS students. These accommodations take various forms. For example, according to one MCPS official, the board advises principals that schools should avoid scheduling tests or other major events on dozens of days of commemoration, during which MCPS expects that many students may be absent or engaged in religious or cultural observations. This case, however, arises from the board's abject refusal to heed widespread and impassioned pleas for accommodation. In the years leading up to 2022, the board apparently determined that the books used in its existing English and language arts curriculum were not representative of many students and families in Montgomery County because they did not include LGBTQ characters. The board therefore decided to introduce into the curriculum what it described as LGBTQ+ inclusive texts. As one email sent by MCPS principals reflects, the board selected the books according to a critical selection repertoire. This repertoire required selectors to review potential texts and ask questions such as, is heteronormativity reinforced or disrupted? Is cisnormativity reinforced or disrupted? And are power hierarchies that uphold the dominant culture reinforced or disrupted? In accordance with this repertoire and other criteria, the board eventually selected 13 LGBTQ inclusive texts for use in the English and Language Arts curriculum from pre-K through 12th grade. At issue in this lawsuit are the 5 LGBTQ inclusive storybooks that are approved for students in kindergarten through 5th grade. In other words, for children who are generally between 5 and 11 years old. A few short descriptions will serve to illustrate the general tenor of the storybooks. Intersection Allies tells the story of several children from different backgrounds, including Kate, who is apparently a transgender child. One page shows Kate in a sex-neutral or sex-ambiguous bathroom, and Kate proclaims, quote, "My friends defend my choices and place. A bathroom, like all rooms, should be a safe space," unquote. Intersection Allies includes a page-by-page book discussion guide that asserts, when we are born, our gender is often decided for us based on our sex. But at any point in our lives, we can choose to identify with one gender, multiple genders, or neither gender. The discussion guide explains that, quote, Kate prefers the pronouns they, their, them, unquote, and asks, what pronouns fit you best? Prince and Knight tells the story of a coming-of-age prince whose parents wish to match him with a kind and worthy bride. After meeting with many ladies, the prince tells his parents that he is looking for something different in a partner by his side. Later in the book, the prince falls into the embrace of a knight after the two finish battling a fearsome dragon. After the knight takes off his helmet, the prince and knight gaze into each other's eyes, and their hearts begin to race. The whole kingdom later applauds on the two men's wedding day. Love, Violet follows a young girl named Violet, who has a crush on her female classmate Mira. Mira makes Violet's heart skip and thunder like 100 galloping horses. Although Violet is initially too afraid to interact with Mira, the two end up exchanging gifts on Valentine's Day. Afterwards, the two girls are seen holding hands and galloping over snowdrifts to see what they might find together. Born Ready, the true story of a boy named Penelope, tells the story of Penelope, a child who was initially treated as a girl. The story is told from the perspective of Penelope, who at one point says, quote, if they'd all stop and listen, I'd tell them about me. Inside, I'm a boy, unquote. When Penelope's mother later assures her that, quote, if you feel like a boy, that's okay, unquote, Penelope responds, no, Mama, I don't feel like a boy. I am a boy. Penelope tells her mother, quote, I love you, Mama, but I don't want to be you. I want to be Papa. I don't want tomorrow to come because tomorrow I'll look like you. Please help me, Mama. Help me to be a boy. Penelope's mother then agrees that she is a boy, and Penelope says, quote, for the first time, my insides don't feel like fire. They feel like warm, golden love, unquote. Later, after the family starts treating Penelope as a boy, Penelope's brother complains that you can't become a boy, you have to be born one. This comment draws a rebuke from Penelope's mother. She says, quote, not everything needs to make sense. This is about love, unquote. Finally, Uncle Bobby's Wedding tells the story of a young girl named Chloe who is informed that her favorite uncle, Bobby, will be getting married to his boyfriend, Jamie. When Bobby and Jamie announce their engagement, everyone is jubilant except Chloe. Chloe says that she does not understand why her uncle is getting married, but her mother responds by explaining, quote, when grown-up people love each other that much, sometimes they get married, unquote. The board suggested that teachers incorporate the new texts into the curriculum in the same way that other books are used, namely to put them on a shelf for students to find on their own, to recommend a book to a student who would enjoy it, to offer the books as an option for literature circles, book clubs, or paired reading groups, or to use them as a read-aloud. And as with all curriculum resources, the board voiced its expectation that teachers use the LGBTQ inclusive books as part of instruction. An MCPS official has made it clear that teachers cannot elect to use the LGBT inclusive books at all. Cannot elect not to use the LGBTQ inclusive books at all. The board also contemplated that instruction involving the LGBTQ inclusive storybooks would include classroom discussion. In anticipation of such discussion, the board hosted a professional development workshop in the summer of 2022, where it provided teachers with a guidance document suggesting how they might respond to student inquiries regarding the themes presented in the books. For example, if a student asserts that two men cannot get married, the guidance document encouraged teachers to respond by saying, quote, "When people are adults, they can get married. Two men who love each other can decide they want to get married," unquote. If a student claims that a character can't be a boy if he was born a girl, teachers were encouraged to respond, quote, "That comment is hurtful," unquote. And if students ask, "What's transgender?" it was recommended that teachers explain, quote, "When we're born, people make a guess about our gender and label us boy or girl based on our body parts. Sometimes they're right and sometimes they're wrong," unquote. The guidance document encouraged teachers to disrupt the either-or thinking of their students. At the same workshop, the board also provided teachers with a guidance document that suggested particular responses to inquiries by parents. For example, if a parent were to ask whether the school was attempting to teach a child to reject the values taught at home, teachers were encouraged to respond that, quote, "Teaching about LGBTQ+ is not about making students think a certain way. It is to show that there is no one right or normal way to be," unquote. The guidance also urged teachers to assure parents that there would not be explicit instruction about gender and sexual identity, but that there may be a need to define words that are new and unfamiliar to students, and that questions and conversations might organically happen. If parents were not comforted by that information, teachers could tell them that parents always have the choice to keep their students home while using these texts. However, it will not be an excused absence. Part A, Subsection 2. The board officially launched the LGBTQ+ inclusive texts into MCPS schools in the 2022-2023 school year. Shortly thereafter, parents began contacting individual teachers, principals, or MCPS staff about the storybooks and asking that their children be excused from classroom instruction related to them. Some parents showed up at the board's public business meetings to express their concerns about the storybook's content. In an early 2023 meeting, for example, one parent represented herself as a voice for parents in her community, many of whom are actually working today and unable to attend. She said that MCPS parents were frustrated because, in their view, educators and administrators are going behind what parents are teaching their kids at home and pushing ideas of gender ideology on their kids. The parents felt that the board was implying to children that their religion, their belief system, and their family tradition is actually wrong. At the same board meeting, one board member responded by saying that, quote, "Some of the testimony today was disturbing to me personally. Transgender, LGBTQ individuals are not an ideology, they are reality. There are religions out there that teach women should only achieve certain subservient roles in life, and MCPS would never think of not having a book in a classroom that showed a woman in a professional role," unquote. The board student member agreed with the sentiment and proclaimed that, quote, "Ignorance and hate does exist within our community, but please know that every student, each of our 160,000 students in our large county, has a place in the school system," unquote. Initially, the board compromised with objecting parents by notifying them when the LGBTQ+ inclusive storybooks would be taught and permitting their children to be excused from instruction involving the books. That policy was consistent with the board's general guidelines for respecting religious diversity, which at the time provided that when possible, schools should try to make reasonable and feasible adjustments to the instructional program to accommodate requests from students or requests from parents or guardians on behalf of their students to be excused from specific classroom discussions or activities that they believed would impose a substantial burden on their religious beliefs. This compromise, however, did not last long. In March 2023, less than a year after the LGBTQ+ inclusive texts were introduced, the board issued a statement declaring that students and families may not choose to opt out of engaging with the storybooks, and that teachers will not send home letters to inform families when inclusive books are read in the future. According to one MCPS official, the board decided to change its policy because, among other things, quote, individual principals and teachers could not accommodate the growing number of opt-out requests without causing significant disruptions to the classroom environment, unquote. The official also stated that permitting some students to exit the classroom while the storybooks were being taught would expose other students to social stigma and isolation. It was therefore announced that any existing accommodations would expire at the end of the 2022-2023 school year. Shortly after the board rescinded parental opt-outs, more than 1,000 parents signed a petition asking the board to restore opt-out rights, and hundreds of displeased parents, including many Muslim and Ethiopian Orthodox parents, appeared at the board's public meetings and implored the board to allow opt-outs. At a May 2023 meeting, one community member testified that thousands of parents felt deeply dismayed and betrayed by the rescission of opt-outs from content that conflicts with their sincerely held religious beliefs. At the same meeting, an MCPS student testified and asked that the board allow students like me to opt out of content and books that contain sensitive and mature topics that go against my religious beliefs. The board was unmoved. After the testimony, several board members and another MCPS official spoke up to clarify that the storybooks would not be used for explicit instruction on sexuality and gender, but rather as part of the literacy curriculum. According to a later news article, one board member recalled that she, quote, felt kind of sorry for the student who testified in favor of opt-outs and wondered to what extent she might have been parroting dogma learned from her parents, unquote. The board member also expressed her view that if parents wanted their children to receive an education that strictly adheres to their religious dogma, they can send their kid to a private religious school. The board member went on to suggest that the objecting parents were comparable to, quote, white supremacists who want to prevent their children from learning about civil rights and xenophobes who object to stories about immigrant families, unquote. The board continues to permit children to opt out of other school activities, including the Family Life and Human Sexuality unit of instruction, for which opt-outs are required under Maryland law. And although the board has amended its guideline for respecting religious diversity to narrow the circumstances in which opt-outs are permissible, those guidelines still allow opt-outs from non-curricular activities such as classroom parties or free time events that involve materials or practices in conflict with a family's religious and/or other practices. Section 1, Part B, Subsection 1. At the time when this lawsuit was filed, petitioners Tamer Mahmoud and Inas Barakat had 3 children enrolled in MCPS, including one who was still in elementary school. Mahmoud and Barakat are Muslims who believe that mankind has been divinely created as male and female, and that gender cannot be unwoven from biological sex to the extent that the two are even distinct, without rejecting the dignity and direction God bestowed on humanity from the start. Mahmoud and Barakat believed that it would be immoral to expose their young, impressionable, elementary-age son to a curriculum that undermines Islamic teaching. And in their view, the storybooks at issue in this lawsuit directly undermine their efforts to raise their son in the Islamic faith because they encourage young children to question their sexuality and gender and to dismiss parental and religious guidance on these issues. After the LGBTQ+ inclusive storybooks were introduced, Mahmoud and Barakat asked to have their son excused from the classroom when Prince and Night was read. Their son's principal initially permitted the boy to sit outside the classroom during that time, but soon after, the board announced that opt-outs would no longer be available. Mahmoud and Barakat then felt religiously compelled to send their son to a private school at significant financial sacrifice. Petitioners Jeff and Svetlana Roman also had a son enrolled in MCPS elementary school when this lawsuit was filed. Jeff Roman is a Catholic, and Svetlana Roman is a Ukrainian Orthodox. They believe that sexuality is expressed only in marriage between a man and a woman for creating life and strengthening the marital union. The Romans further believe that gender and biological sex are intertwined and inseparable, and that the young need to be helped to accept their own body as it was created. The Romans understand that their son loves his teachers and implicitly trusts them, and so they fear that allowing those teachers to teach principles about sexuality or gender identity that conflict with their religious beliefs would significantly interfere with their ability to form their son's religious faith and religious outlook on life. After the LGBTQ plus inclusive storybooks were introduced, the Romans asked the principal of their son's elementary school to notify them when the books were being read and to excuse their son from that instruction. The Romans were initially told that it was their right to ask their son not be present when the books are read, but they were later informed that notice and opt-out rights would no longer be provided. Thus, the Romans, like Mahmoud and Barakat, were religiously compelled to send their son to private school at significant expense. Petitioners Chris and Melissa Persack have 2 elementary-age daughters who attend public school in Montgomery County. The Persacks are Catholics who believe that all humans are created as male or female, and that a person's biological sex is a gift bestowed by God that is both unchanging and integral to that person's being. The Persacks believe that children, particularly those in elementary school, are highly impressionable to ideological instruction presented in children's books or by school teachers. They are concerned that the board's LGBTQ plus inclusive storybooks are being used to impose an ideological view of family life and sexuality that characterizes any divergent beliefs as hurtful. They think that such instructions will undermine their efforts to raise their children in accordance with their religious beliefs. The Persacks' daughters were initially permitted to opt out of instructions related to the storybooks, but they no longer have that option. The final petitioner, Kids First, is an unincorporated association of parents and teachers that was formed to advocate for the return of parental notice and opt-out rights in the Montgomery County Public Schools. One of Kids First's board members, Grace Morrison, has a daughter who previously attended an MCPS elementary school. Morrison's daughter has Down syndrome and attention deficit disorder. She previously required special accommodations from her public school, including a full-time, one-on-one paraeducator. Morrison's daughter also received special services from the school, such as speech and occupational therapy. Morrison and her husband are Catholics who believe that marriage is the lifelong union of one man and one woman, and that gender is interwoven with sex. Due to their daughter's learning challenges, they fear that she doesn't understand or differentiate instructions from her teachers and parents, and that they won't be able to contradict what she hears from teachers. Because of the services provided to her disabled daughter in public school, Morrison faced enormous pressure to keep her daughter enrolled. She asked that her daughter be excused from LGBTQ plus inclusive instruction, even after the board's decision to rescind opt-outs. She was told, however, that opt-outs would not be possible. As a result, the Morrisons felt religiously compelled to remove their daughter from public school. They anticipate that it will cost at least $25,000 per year to replace the academic and other services that their daughter formerly received from the public school system. Faced with the board's decision to rescind opt-outs, petitioners filed this lawsuit in the United States District Court for the District of Maryland. Among other things, they asserted that the board's no opt-out policy infringed their right to the free exercise of their religion. They sought a preliminary and permanent injunction prohibiting the school board from forcing their children and other students, over the objection of their parents, to read, listen to, or discuss the storybooks. In support of their request, the parents relied heavily on this court's decision in Wisconsin v. Yoder, 406 U.S. 205. That case concerned Amish parents who wished to withdraw their children from conventional schooling after the 8th grade, in direct contravention of a Wisconsin law requiring children to attend school until the age of 16. In Yoder, we recognized that parents have a right to direct the religious upbringing of their children, and that this right can be infringed by laws that pose a very real threat of undermining the religious beliefs and practices that parents wish to instill in their children. Given the substantial burdens that Wisconsin's compulsory attendance law placed on the religious practices of the Amish, we held that it carried with it precisely the kind of objective danger to the free exercise of religion that the First Amendment was designed to prevent. In the present case, the parents asserted that Yoder's principles applies to their situation, and they therefore asked for a preliminary injunction permitting their children to opt out of the challenged instruction pending the completion of their lawsuit. The district court denied that relief. It characterized the petitioner's primary argument as an objection to school indoctrination and asserted that the petitioners had not identified any case recognizing a free exercise violation based on indoctrination. It dismissed Yoder as sui generis and inexorably linked to the Amish community's unique religious beliefs and practices. And although the district court acknowledged that the LGBTQ+ inclusive curriculum might result in petitioners being less likely to succeed in raising their children in their religious faiths, it nonetheless held that the curriculum was likely consistent with the Free Exercise Clause. A divided panel of the Fourth Circuit affirmed. The majority did not expressly endorse the district court's view regarding the constitutionality of, quote, indoctrination, unquote, but it suggested that petitioners could succeed on their free exercise claim only if they could show direct or indirect coercion arising out of the exposure to the storybooks. And the majority found that the evidence in the record was insufficient to make that showing. The majority expressed concern that the record does not show how the storybooks are actually being used in classrooms. And without such evidence, the majority held, petitioners could not obtain a preliminary injunction because it could not simply be assumed that any past lessons had or that any future lessons would, quote, cross the line and pressure students to change their views or act contrary to their faith, unquote. As for petitioners' reliance on Yoder, the majority quickly dismissed that argument, describing the decision as, quote, markedly circumscribed and tailored to the specific evidence in its record, unquote. Judge Quattlebaum dissented. He accepted the parents' representation that their faith compels that they teach their children about sex, human sexuality, gender, and family life. And he acknowledged that their claim that the messages from the books conflict with and undermine the sincerely held religious beliefs they hold and seek to convey to their children. Judge Quattlebaum therefore concluded that the board had forced the parents to make a choice, either adhere to their faith or receive a free public education for their children. Forcing parents to make such a choice was, in his view, a burden on their religious exercise. After the Fourth Circuit ruled, the parents asked this court to review the decision, and we granted their petition for a writ of certiorari. We now hold that the parents have shown that they are entitled to a preliminary injunction and reverse the judgment below. Section 2. Our Constitution proclaims that Congress shall make no law prohibiting the free exercise of religion. That restriction applies equally to the states by way of the 14th Amendment. And the right to free exercise, like other First Amendment rights, is not shed at the schoolhouse gate. Government schools, like all government institutions, may not place unconstitutional burdens on religious exercise. The parents assert that the board's introduction of the LGBTQ+ inclusive storybooks, combined with its decision to withhold notice and opt-outs, unconstitutionally burdens their religious exercise. At this stage, the parents seek a preliminary injunction that would permit them to have their children excused from instructions related to the storybooks while this lawsuit proceeds. To obtain that form of relief, the parents must show that they are likely to succeed on the merits, that they are likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in their favor, and that an injunction would be in the public interest. The parents have made that showing. Section 3. To begin, we hold that the parents are likely to succeed on their claim that the board's policies unconstitutionally burden their religious exercise. We have long recognized the rights of parents to direct the religious upbringing of their children, and we have held that those rights are violated by government policies that substantially interfere with the religious development of children. Such interference, we have observed, carries with it precisely the kind of objective danger to the free exercise of religion that the First Amendment was designed to prevent. For the reasons explained below, we conclude that such an objective danger is present here. Section 3, Part A. We start by describing the nature of the religious practice at issue here and explaining why it is burdened by the board's policies. Subsection 1. At its heart, The Free Exercise Clause of the First Amendment protects, quote, the ability of those who hold religious beliefs of all kinds to live out their faiths in daily life through the performance of religious acts, unquote. And for many people of faith across the country, there are few religious acts more important than the religious education of their children. Indeed, for many Christians, Jews, Muslims, and others, the religious education of children is not merely a preferred practice, but rather a religious obligation. The parent petitioners in this case reflect this reality. They all believe they have a sacred obligation or a God-given responsibility to raise their children in a way that is consistent with their religious beliefs and practices. The practice of educating one's children in one's religious beliefs, like all religious acts and practices, receives a generous measure of protection from our Constitution. Drawing on enduring American tradition, we have long recognized the rights of parents to direct the religious upbringing of their children. And this is not merely a right to teach religion in the confines of one's own home. Rather, it extends to the choices that parents wish to make for their children outside the home. It protects, for example, a parent's decision to send his or her child to a private religious school instead of a public school. Due to financial and other constraints, however, many parents have no choice but to send their children to a public school. As a result, the right of parents to direct the religious upbringing of their children would be an empty promise if it did not follow those children into the public classroom. We have thus recognized limits on the government's ability to interfere with a student's religious upbringing in a public school setting. An early example comes from our decision in West Virginia Board of Education v. Barnett, 319 U.S. 624, from 1943. In that case, we considered a resolution adopted by the West Virginia State Board of Education that required students to participate in the salute honoring the nation represented by the flag. If students failed to comply, they faced expulsion and could not be readmitted until they yielded to the state's command. A group of plaintiffs sued to prevent the enforcement of this policy against Jehovah's Witnesses, who considered the flag to be a graven image and refused to salute it. The challengers asserted that the policy was, among other things, an unconstitutional denial of religious freedom. We agreed that the policy could not be squared with the First Amendment. The effect of the state's policy, we observed, was to condition access to public education on making a prescribed sign and profession at the same time to coerce attendance by punishing both parent and child. Although the policy did not clearly require students to forego any contrary convictions of their own and become unwilling converts, it nonetheless required a particular affirmation of a belief and an attitude of mind. For a public school to require students to make such an affirmation, in contravention of their beliefs and those of their parents, was to go further than the First Amendment would allow. Barnett dealt with an especially egregious kind of direct coercion, a requirement that students make an affirmation contrary to their parents' religious beliefs. But that does not mean that the protections of the First Amendment extend only to policies that compel children to depart from the religious practices of their parents. To the contrary, in Yoder, we held that the Free Exercise Clause protects against policies that impose more subtle forms of interference with the religious upbringing of children. Yoder concerned a Wisconsin law that required parents to send their children to public or private school until the age of 16. Respondents Jonas Yoder, Wallace Miller, and Aidan Yutzi were members of Wisconsin's Amish community who refused to send their children to public school after the completion of the 8th grade. In their view, the values taught in high school were in marked variance with Amish values and the Amish way of life, and would result in an impermissible exposure of their children to the worldly influence in conflict with their beliefs. In response, this court observed that formal high school education would place Amish children in an environment hostile to Amish beliefs, with pressure to conform to the styles, manners, and ways of the peer group, and that it would take them away from their community, physically and emotionally, during the crucial and formative adolescent period of life. In short, the court concluded, high school attendance interposes a serious barrier to the integration of the Amish child into the Amish religious community. In Yoder, unlike in Barnett, there was no suggestion that the compulsory attendance law would compel Amish children to make an affirmation that was contrary to their parents or their own religious beliefs. Nor was there a suggestion that Amish children would be compelled to commit some specific practice forbidden by their religion. Rather, the threat to religious exercise was premised on the fact that the high school education would expose Amish children to worldly influences in terms of attitudes, goals, and values contrary to their beliefs, and would substantially interfere with the religious development of the Amish child. That interference, the court held, violated the parents' free exercise rights. The compulsory education law carried with it precisely the kind of objective danger to the free exercise of religion that the First Amendment was designed to prevent, because it placed Amish children into an environment hostile to Amish beliefs, where they would face pressure to conform to contrary viewpoints and lifestyles. As our decision in Yoder reflects, the question whether a law substantially interferes with the religious development of a child will always be fact-intensive. It will depend on the specific religious beliefs and practices asserted, as well as the specific nature of the educational requirement or curricular feature at issue. Educational requirements targeted towards very young children, for example, may be analyzed differently from educational requirements for high school students. A court must also consider the specific context in which the instruction or materials at issue are presented. Are they presented in a neutral manner, or are they presented in a manner that is hostile to religious viewpoints and designed to impose upon students a pressure to conform? We now turn to the application of these principles to this case. Section 3, Part A, Subsection 2. In light of the record before us, we hold that the Board's introduction of the LGBTQ+ inclusive storybooks, combined with its decision to withhold notice to parents and forbid opt-outs, substantially interferes with the religious development of their children and imposes the kind of burden on religious exercise that Yoder found unacceptable. To understand why, start with the storybooks themselves. Like many books targeted at young children, the books are unmistakably normative. They are clearly designed to present certain values and beliefs as things to be celebrated and certain contrary values and beliefs as things to be rejected. Take, for example, the message sent by the books concerning same-sex marriage. Many Americans advocate with utmost sincere conviction that, by divine precepts, same-sex marriage should not be condoned. That group includes each of the parents in this case. The storybooks, however, are designed to present the opposite viewpoint to young, impressionable children who are likely to accept without question any moral messages conveyed by their teacher's instruction. For example, the book Prince and Knight clearly conveys the message that same-sex marriage should be accepted by all as a cause for celebration. The young reader is guided to feel distressed at the prince's failure to find a princess, and then to celebrate when the prince meets his male partner. The book relates that, quote, on the two men's wedding day, the air filled with cheer and laughter, for the prince and his shining knight would live happily ever after, unquote. Those celebrating the same-sex wedding are not just family members and close friends, but the entire kingdom. For young children to whom this and the other story books are targeted, such celebration is liable to be processed as having moral connotations. If this same-sex marriage makes everyone happy and leads to joyous celebration by all, doesn't that mean it is in every respect a good thing? High school students may understand that widespread approval of a practice does not necessarily mean that everyone should accept it, but very young children are most unlikely to appreciate that fine point. Uncle Bobby's Wedding, the only book that the dissent is willing to discuss in any detail, conveys the same message more subtly. The atmosphere is jubilant at Uncle Bobby and his boyfriend's announcement of their engagement. Quote, everyone was smiling and talking and crying and laughing, unquote. The book's main character, Chloe, does not share this excitement. I don't understand, she exclaims. Why is Uncle Bobby getting married? The book is coy about the precise reason for Chloe's question, but the question is used to tee up a direct message to young readers. Bobby and Jamie love each other, said Mommy. When grown-ups people love each other that much, sometimes they get married. The book therefore presents a specific, if subtle, message about marriage. It asserts that two people can get married regardless of whether they are the same or the opposite sex, so long as they, quote, love each other, unquote. That view is now accepted by a great many Americans, but it is directly contrary to the religious principles that the parents in this case wish to instill in their children. It is significant that this book does not simply refer to same-sex marriage as an existing practice. Instead, it presents acceptance of same-sex marriage as a perspective that should be celebrated. The book's narrative arc reaches its peak with the actual event of Uncle Bobby's wedding, which is presented as a joyous event that is met with universal approval. And again, there are many Americans who would view the event that way, and it goes without saying that they have every right to do so. But other Americans wish to present a different moral message to their children, and their ability to present that message is undermined when the exact opposite message is positively reinforced in the public school classroom at a very young age. Next, consider the messages sent by the storybooks on the subject of sex and gender. Many Americans, like the parents in this case, believe that biological sex reflects divine creation, that sex and gender are inseparable, and that children should be encouraged to accept their sex and to live accordingly. But the challenge storybooks encourage children to adopt a contrary viewpoint. Intersection Allies presents a transgender child in a sex-ambiguous bathroom and proclaims that a bathroom, like all rooms, should be a safe space. The book also includes a discussion guide that asserts that, quote, at any point in our lives, we can choose to identify with one gender, multiple genders, or neither gender, unquote. And it asks children, what pronouns fit you best? The book and the accompanying discussion guide present as a settled matter a hotly contested view of sex and gender that sharply conflicts with the religious beliefs that the parents wish to instill in their children. The book Born Ready presents similar ideas in an even less veiled manner. The book follows the story of Penelope, an apparently biological female who asserts, quote, I am a boy, unquote. Not only does the story convey the message that Penelope is a boy simply because that is what she chooses to be, but it slyly conveys a positive message about transgender medical procedures. Penelope says the following to her mother, quote, I love you, Mama, but I don't want to be you. I want to be Papa. I don't want tomorrow to come because tomorrow I'll look like you. Please help me, Mama. Help me to be a boy, unquote. Penelope's mother then agrees that Penelope is a boy, and Penelope exclaims, quote, for the first time, my insides don't feel like fire. They feel like warm, golden love, unquote. To young children, the moral implication of the story is that it is seriously harmful to deny a gender transition and that transitioning is a highly positive experience. The book goes so far as to present a contrary view as something to be reprimanded. When the main character's brother says, quote, you can't become a boy, you have to be born one, unquote, his mother corrects him by saying, quote, not everything needs to make sense. This is about love, unquote. The upshot is that it is hurtful, perhaps even hateful, to hold the view that gender is inextricably bound with biological sex. These books carry with them a very real threat of undermining the religious beliefs that the parents wish to instill in their children. Like the compulsory high school education considered in Yoder, these books impose upon children a set of values and beliefs that are hostile to their parents' religious beliefs. As the books exert upon children a psychological pressure to conform to their specific viewpoints, the books therefore present the same kind of objective danger to the free exercise of religion that we identified in Yoder. That objective danger is only exacerbated by the fact that the books will be presented to young children by authority figures in elementary schools. As representatives of the board have admitted, there is an expectation that teachers use the LGBTQ+ inclusive books as part of instruction, and there will be discussion that ensues. The board has left little mystery as to what that discussion might look like. The board provided teachers with suggested responses to student questions related to the books, and the responses make it clear that instructions related to storybooks will substantially interfere with the parents' ability to direct the religious development of their children. In response to a child who states that two men can't get married, teachers are encouraged to respond, quote, two men who love each other can decide they want to get married. There are so many different kinds of families and ways to be a family, unquote. If a child says, quote, he can't be a boy if he was born a girl, unquote, the teacher is urged to respond, quote, that comment is hurtful, unquote. If a child asks, what's transgender? It is suggested that the teacher answer, quote, when we're born, people make a guess about our gender. Sometimes they're right, and sometimes they're wrong, unquote. In other contexts, we have recognized the potentially coercive nature of classroom instructions of this kind. The state exerts great authority and coercive power through public schools because of the students' emulation of teachers as role models and the children's susceptibility to peer pressure. Young children, like those of petitioners, are often impressionable and implicitly trust their teachers. Here, the board requires teachers to instruct young children using storybooks that explicitly contradict their parents' religious views, and it encourages the teachers to correct the children and accuse them of being hurtful when they express a degree of religious confusion. Such instruction carries with it precisely the kind of objective danger to the free exercise of religion that the First Amendment was designed to prevent. Section 3, Part A, Subsection 3. None of the counterarguments raised by the dissent, the board, the courts below, or the board's amici give us any reason to doubt the existence of a burden here. Subsection 3, Subpart A. To start, we cannot accept the board's characterization of the LGBTQ+ inclusive instruction as mere exposure to objectionable ideas or as lessons in mutual respect. As we have explained, the storybooks unmistakably convey a particular viewpoint about same-sex marriage and gender. And the board has specifically encouraged teachers to reinforce this viewpoint and to reprimand any children who disagree. That goes far beyond mere exposure. We similarly disagree with the dissent's deliberately blinkered view that these storybooks and related instruction merely expose students to the message that LGBTQ people exist, and teach them to treat each other with kindness. In making this argument, the dissent ignores what anyone who reads these books can readily see. It ignores the message that the authors plainly intended to convey. And, what is perhaps most telling, it ignores the board's stated reason for inserting these books into the curriculum and much of the instructions it gave to teachers. Only by airbrushing the record can the dissent claim that the books and instruction are just about exposure and kindness. In any event, the board and the dissent are mistaken when they rely extensively on the concept of exposure. The question in cases of this kind is whether the educational requirement or curriculum at issue would substantially interfere with the religious development of the child or pose a very real threat of undermining the religious beliefs and practices the parents wish to instill in the child. Whether or not a requirement or curriculum could be characterized as exposure is not the touchstone for determining whether that line is crossed. Section 3, Part A, Subsection 3, Subpart B. We are also unpersuaded by the board's reliance, echoed by the dissent, on our decision in Bowen v. Roy and Ling v. Northwest Indian Cemetery Protective Association. In Bowen, a father mounted a free exercise challenge to the government's use of a Social Security number associated with his daughter. And in Ling, Native Americans and other plaintiffs raised a free exercise challenge to the construction of a paved road on federal land. In those cases, we held that the Free Exercise Clause simply cannot be understood to require the government to conduct its own internal affairs in ways that comport with the religious beliefs of particular citizens, even when the conduct of such internal affairs might result in incidental interference with an individual's spiritual activities. And we emphasized that conclusion was appropriate because the government actions at issue did not discriminate against religion or coerce individuals into acting contrary to their religious beliefs. These cases have no application here. The government's operation of the public schools is not a matter of internal affairs akin to the administration of Social Security or the selection of filing cabinets. It implicates direct, coercive interactions between the state and its young residents. The public school imposes rules and standards of conduct on its students and holds a limited power to discipline them for misconduct. If questions of public school curriculum were purely a matter of internal affairs, one could imagine that other First Amendment protections, such as the right to free speech or the right to be free from established religion, would also be inapplicable to the public school context. But our precedents plainly provide otherwise. Subsection 3, Part A, Subsection 3, Subpart C. Next, we cannot agree with the decision of the lower courts to dismiss our holding in Yoder out of hand. Although the decision turns on a close analysis of the facts in the record, there is no reason to conclude that the decision is sui generis or uniquely tailored to its specific evidence as the courts below have reasoned. We have never confined Yoder to its facts. To the contrary, we have treated it like any other precedent. We have at times relied on it as a statement of general principles, and we have distinguished it when appropriate. True, we noted in Yoder that the Amish had made a convincing showing, one that probably few other religious groups or sects could make. but that language must be read in the context of the specific claims raised by the Amish respondents. They did not challenge a discrete educational requirement or element of the curriculum like the plaintiffs in Barnett. Instead, they asserted a right to withdraw their children from all conventional schooling after a certain age. Such a claim required them to show that the practice of formal education after the 8th grade would substantially and systematically interfere with the religious development of their children. It was on that point that they had made a convincing showing that others might struggle to make. But that says nothing at all about whether other parents could make the same convincing showing with respect to more specific educational requirements. Yoder is an important precedent for this court, and it cannot be breezily dismissed as a special exception granted to one particular religious minority. It instead embodies a principle of general applicability, and that principle provides more robust protection for religious liberty than the alarmingly narrow rule that the dissent propounds. The dissent sees the Free Exercise Clause's guarantee of nothing more than protection against compulsion or coercion to renounce or abandon one's religion. Under this test, even instruction that denigrates or ridicules students' religious beliefs would apparently be allowed. We reject this chilling vision of the power of the state to strip away the critical rights of parents to guide the religious development of their children. Yoder and Barnett embody a very different view of religious liberty, one that comports with the fundamental values of the American people. Section 3, Part A, Subsection 3, Subpart D. We also disagree with the Fourth Circuit's view that the record before us is too threadbare to demonstrate a burden on religious exercise. That court faulted the parents for failing to make specific allegations describing how the books are actually being used in classrooms. But when a deprivation of First Amendment rights is at stake, a plaintiff need not wait for the damage to occur before filing suit. Instead, to pursue a pre-enforcement challenge, a plaintiff must show that the threatened injury is certainly impending or there is a substantial risk that the harm will incur. Here, the parents have undoubtedly made that showing. The board does not dispute that it is introducing the storybooks into classrooms, that it is requiring teachers to use them as part of instruction, and that it has encouraged teachers to approach classroom discussions in a certain way. We do not need to wait and see how a particular book is used in a particular classroom on a particular day before evaluating the parents' First Amendment claims. We need only decide whether, if teachers act according to the clear and undisputed instructions of the board, a burden on religious exercise will occur. Besides, it is not clear how the Fourth Circuit expects the parents to obtain specific information about how a particular book was used or is planned for use at a particular time. The board has stated that it will not notify parents when the books are being read, and it is not realistic to expect parents to rely on after-the-fact reports by their young children to determine whether the parents' free exercise rights have been burdened. In circumstances like these, where the board has clearly stated how it intends to proceed, the parents may base their First Amendment claim on the board's representations. Section 3, Part A, Subsection 3, Subpart E. Finally, we reject the alternatives offered to parents by those who would defend the judgment below. The first of those proposed alternatives is the suggestion that any parents who are unhappy about the instruction in question can simply place their children in private school or educate them at home. The availability of this option is no answer to the parents' First Amendment objections. As we have previously held, when the government chooses to provide public benefits, it may not condition the availability of those benefits upon a recipient's willingness to surrender his religiously impelled status. That is what the board has done here. Public education is a public benefit, and the government cannot condition its availability on parents' willingness to accept a burden on their religious exercise. Moreover, since education is compulsory in Maryland, the parents are not being asked simply to forgo a public benefit. They have an obligation, enforceable by fine or imprisonment, to send their children to public school unless they find an adequate substitute, and many parents cannot afford such a substitute. The provision of education is an expensive endeavor. In Montgomery County, as in many other jurisdictions, public education is the most significant expenditure in the county budget by a wide margin. In the 2025-2026 school year, the county expects to spend $3.6 billion on public schools, amounting to roughly $22,644 per student. To help finance that budget, Montgomery County will levy property taxes and income taxes on all residents, regardless of whether they send their children to a public school. Private elementary schools in Montgomery County are expensive. Many cost $10,000 or more per year prior to financial aid. And homeschooling comes with a hefty price as well. It requires at least one parent to stay at home during the normal workday to educate children, thereby foregoing additional income opportunities. It is both insulting and legally unsound to tell parents that they must abstain from public education in order to raise their children in their religious faiths, when alternatives can be prohibitively expensive and they already contribute to financing the public schools. Although the dissent does not follow suit in proposing that the objecting parents send their children to private school, it offers two other alternatives that are no better. First, it suggests that the parents in this case have no legitimate cause for concern because enforcement of the board's policy would not prevent them from teaching their religious beliefs and practices to their children at home. This suggestion complements the dissent's narrow view of the rights of parents to raise their children in accordance with their faith. According to the dissent, parents who send their children to public school must endure any instruction that falls short of direct compulsion or coercion and must try to counteract that teaching at home. The free exercise clause is not so feeble. The parents in Barnett and Yoder were similarly capable of teaching their religious values at home, but that made no difference in the First Amendment analysis in those cases. Mustering one last alternative, the dissent asserts that under its approach, the parents would remain free to raise objections to specific material through the democratic process. In making this argument, the dissent seems to confuse our country with those in which laws enacted by Parliament or another legislative body cannot be challenged in court. In this country, that is not so. Here, the Bill of Rights and the doctrine of judicial review protects individuals who cannot obtain legislative change. The First Amendment protects the parents' religious liberty, and they have every right to file suit to protect that right. Section 3, Part B. For these reasons, we conclude that the board's introduction of the LGBTQ+ inclusive storybooks, combined with its no opt-out policy, burdens the parents' right to the free exercise of religion. We now turn to the question whether that burden is constitutionally permitted. Part B, Section 1. Under our precedents, the government is generally free to place incidental burdens on religious exercise so long as it does so pursuant to a neutral policy that is generally applicable. Thus, in most circumstances, two questions remain after a burden on religious exercise is found. First, a court must ask if the burdensome policy is neutral and generally applicable. Second, if the first question can be answered in the negative, a court will proceed to ask whether the policy can survive strict scrutiny. Under that standard, the government must demonstrate that its course was justified by a compelling state interest and was narrowly tailored in pursuit of that interest. Here, the character of the burden requires us to proceed differently. When the burden imposed is of the same character as that imposed in Yoder, we need not ask whether the law at issue is neutral or generally applicable before proceeding to strict scrutiny. That much is clear from our decisions in Yoder and Smith. In Yoder, the court rejected the contention that the case could be disposed of on the grounds that Wisconsin's requirement applies uniformly to all citizens of the state and does not, on its face, discriminate against religions or a particular religion. Instead, the court bypassed those issues and proceeded to subject the law to close judicial scrutiny, asking whether the state's interest in its system of compulsory education was so compelling that even the established religious practices of the Amish must give way. Then, in Smith, we recognized Yoder as an exception to the general rule that governments may burden religious exercise pursuant to neutral and generally applicable laws. Specifically, we described Yoder as a case in which we have held that the First Amendment bars application of a neutral, generally applicable law to religiously motivated action. And we explained that the general rule did not apply in Yoder because of the special character of the burden in that case. Thus, when a law imposes a burden of the same character as that in Yoder, strict scrutiny is appropriate regardless of whether the law is neutral or generally applicable. As we have explained, the burden in this case is of the exact same character as the burden in Yoder. The board's policies, like the compulsory attendance requirement in Yoder, substantially interferes with the religious development of the parents' children. And those policies pose a very real threat of undermining the religious beliefs and practices that the parents wish to instill in their children. We therefore proceed to consider whether the policies can survive strict scrutiny. Section 3, Part B, Subsection 2. To survive strict scrutiny, a government must demonstrate that its policy advances interests of the highest order and is narrowly tailored to achieve those interests. In its filing before us, the Board asserts that its curriculum and no opt-out policy serves its compelling interest in maintaining a school environment that is safe and conducive to learning for all students. It relies on the statements of an MCPS official who testified that permitting opt-outs would result in significant disruptions to the classroom environment and would expose certain students to social stigma and isolation. We do not doubt that, as a general matter, schools have a compelling interest in having an undisrupted school session conducive to the students' learning. But the Board's conduct undermines its assertion that its no opt-out policy is necessary to serve that interest. As we have noted, the Board continues to permit opt-outs in a variety of other circumstances, including for non-curricular activities and the Family Life and Human Sexuality Unit of Instruction, for which opt-outs are required under Maryland law. And the Board goes to great lengths to provide independent, parallel programming for many other students, such as those who qualify as emergent multilingual learners, EMLs, or qualify for an individualized educational program. This robust system of exceptions undermines the Board's contention that the provision of opt-outs to religious parents would be infeasible or unworkable. The Board's attempt to distinguish the other programs for which it provides opt-outs is unconvincing. The Board asserts that the Family Life and Human Sexuality Unit of Instruction is meaningfully different because it is discrete and predictably timed, and therefore schools can accommodate opt-outs without producing the same absenteeism and administrability concerns. But this assertion only tends to show that the Board's concerns about administrability are a product of its own design. If the Board can structure the Family Life and Human Sexuality curriculum to more easily accommodate opt-outs, it could structure instruction concerning the LGBTQ+ inclusive storybooks similarly. The Board cannot escape its obligation to honor parents' free exercise rights by deliberately designing its curriculum to make parental opt-outs more cumbersome. The Board also suggests that permitting opt-outs from the LGBTQ+ inclusive storybooks would be especially unworkable because, when it permitted such opt-outs in the past, they resulted in unsustainably high numbers of absent students. But again, the Board's concern is self-inflicted. The Board is doubtless aware of the presence in Montgomery County of substantial religious communities whose members hold traditional views on marriage, sex, and gender. When it comes to instruction that would burden the religious exercise of parents, the Board cannot escape its obligations under the Free Exercise Clause by crafting a curriculum that is so burdensome that a substantial number of parents elect to opt out. There is no de maximis exception to the Free Exercise Clause. Nor can the Board's policies be justified by its asserted interest in protecting students from social stigma and isolation. In Maryland, the Family Life and Human Sexuality Unit of Instruction includes discussions about sexuality and gender. Yet the Board has not suggested that the legally required provision of opt-outs from that curriculum has resulted in stigma or isolation. Even if it did, the Board cannot purport to rescue one group of students from stigma and isolation by stigmatizing and isolating another. A classroom environment that is welcoming to all students is something that can be commended. But such an environment cannot be achieved through hostility toward the religious beliefs of students and their parents. We acknowledge that courts are not school boards or legislatures and are ill-equipped to determine the necessity of discrete aspects of the state's program of compulsory education. It must be emphasized that what the parents seek here is not the right to micromanage the public school curriculum, but rather to have their children opt out of a particular educational requirement that burdens their well-established right to direct the religious upbringing of their children. We express no view on the educational value of the Board's proposed curriculum, other than to state that it places an unconstitutional burden on the parents' religious exercise if it is imposed with no opportunity for opt-outs. Providing such an opportunity would give the parents no substantive control over the curriculum itself. Several states across the country permit broad opt-outs from discrete aspects of the public school curriculum without widespread consequences. And prior to the introduction of the LGBTQ+ inclusive storybooks, the board's own guidelines for respecting religious diversity gave parents a broad right to have their children excused from specific aspects of the school's curriculum. These facts belie any suggestion that the provision of parental opt-outs in circumstances like these will impose impossible administrative burdens on the school. Section 4. The board's introduction of the LGBTQ+ inclusive storybooks, along with its decision to withhold opt-outs, places an unconstitutional burden on the parents' right to the free exercise of their religion. The parents have therefore shown that they are likely to succeed in their free exercise claims. They have likewise shown entitlement to a preliminary injunction pending the completion of this lawsuit. In the absence of an injunction, the parents will continue to be put to a choice: either risk their child's exposure to burdensome instruction or pay substantial sums for alternative educational services. As we have explained, that choice unconstitutionally burdens the parents' religious exercise and the loss of First Amendment freedoms. For even minimal periods of time, unquestionably constitutes irreparable injury. Furthermore, in light of the strong showing made by the parents here and the lack of a compelling interest supporting the board's policies, an injunction is both equitable and in the public interest. The petitioners should receive preliminary relief while this lawsuit proceeds. Specifically, until all appellate review in this case is completed, the board should be ordered to notify them in advance whenever one of the books in question or any other similar book is to be used in any way, and to allow them to have their children excused from that instruction. The judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered.